All rise. This court is now in session. Please be seated.
Homicide case, and I'll reserve 1 minute for rebuttal. And I find it quite a coincidence that one of the issues I'm going to focus on is sufficiency of the evidence following the prior argument. I venture to guess when I first appeared in this court in 1981, that was one of my issues. It's been one of my issues ever since for the last 42 years. And echoing Mr. McNally, sometimes I wonder whether defense lawyers look at it closely. That's one of the two issues in this case, and I did look at it closely and discovered that, like Mr. McNally said, sometimes it's an afterthought. We put it in our brief, we don't ever argue, but I'm going to argue in this one. Because this court has given relief in the past, and I've been remiss in not remembering that or looking at that. But very quickly, and I know the court knows the facts, I'm going to focus on what's not in the facts. But just briefly, this was a tragedy. The defendant crashed into another vehicle, causing a death. His driving was beyond erratic. It was kind of strange, stopping in the middle of the road and things like that. Went across the median and struck the vehicle. On the sufficiency of the evidence, our position is that there is insufficient evidence, and I understand the state is entitled to the strongest legitimate view of the case. Presumption of innocence is gone. But I'm concerned about, in this case, that there are no facts, there was no testimony by the state that the defendant was impaired. The testimony was to the contrary. He crashed. Citizens saw him there bleeding. He was talking crazy. No question about that. Columbia police detective comes up and reads him his rights, but testifies that he was clear-headed, he understood, no slurred speech, no indication of impairment. That was his testimony. Another police officer interviewed him later, offered no testimony about impairment. There was no evidence that he was impaired. So we're going to be arguing, the state will argue.
What about the fentanyl in his bloodstream? What about the needles in the car? There was various paraphernalia in the car. What about the erratic driving? Is it not a reasonable inference from that proof that he was impaired, counsel?
He admitted he shot up heroin. It turns out it was fentanyl.
Right.
The TBI expert testified that she could not tell you how long the effects of fentanyl would last. It's not in the record, but I think she pretty much admitted that it's brief.
But didn't one of the first witnesses on the scene say that the defendant was talking out of his mind? He was saying, I love opiates, I love Opana.
Yeah, that's all on the record.
Is that not something a jury could infer, that the defendant was impaired at that point?
Well, impaired on what? What evidence is there that he's impaired? None, in my view. I think this was recklessness. He shot up sometime earlier, but there's no proof in the record. Every element of the offense has to be established on sufficiency of the evidence, because I went back and looked at some of the cases. The reckless killing of another, where the proximate cause of the death is intoxication. So you go to the definition under the DUI statute of intoxication, and there's got to be impairment. So my argument is, what evidence is there that he was impaired by this fentanyl that he took sometime earlier? And quite frankly, his actions almost suggest some mental issue rather than impairment. I'm worried about a jury speculating as opposed to inferring something. There has to be facts to support an inference.
Sure. Sure, and so that was my initial question,
Okay.
and I think Judge Hickson's question. Why isn't the evidence about the fentanyl? Why isn't all the other paraphernalia in the car? Why isn't his crazy comments upon people responding to the scene? Why can we not view that? Why can't a rational juror view that and make the logical inference from that evidence that he was impaired?
Because state witnesses said there was no evidence of impairment. That's why.
I'm sorry. They said there was no evidence? There was testimony there?
There was, yes. You know, I asked those questions. You know, the detective, I read him his rights. He was clear-headed. No slurred speech. No sign of impairment. That was the testimony of that detective. Another law enforcement officer who interviewed him about taking the blood offered no testimony about impairment. So the jury has...
Well, there's a difference between offering no testimony and then saying that an individual was not impaired.
Well, there is, if I'm remembering the record, one of the detectives said there was no sign of impairment, because I remember asking him. So if there's no evidence from the experts and law enforcement officers that deal with these people all the time, nothing about impairment, then I submit the jury's speculating, not inferring. Yeah, there's needles. I mean, the facts are he shot up. The question is there sufficient evidence? Just based on that, when you've got evidence to the contrary, that the prong about intoxication has been met. We submit that it's not.
Didn't he admit he shot up and he passed out?
He did admit that.
So what caused him passing out?
Well, is it going to be an inference or speculation? That's the.
Well,
there was no. I'm sorry. I didn't mean to.
No, you can go ahead in a minute, but the inferences are in the favor of the state, right?
Yes.
Okay. So is that an inference or a speculation?
I think it's speculation in view of the fact that the state's witnesses are saying, you know, he was right there talking to him, read him his rights, and he testified, I saw no sign of impairment.
How much later was that in the record?
It was at the scene.
At the
That
scene.
one was at the scene.
Okay. And the driving had obviously taken place before, because
Yeah.
we had the wreck, and the passing out after he shot up had taken place before, right?
Yeah. And the driving was crazy, and the yelling and everything he was doing was crazy. But is there sufficient evidence to say that it was the result of intoxication? You got to be intoxicated on something. Is it an inference or speculation when the proof, I submit, shows that there were no signs of impairment? It has to be, in my view, it would have to be speculation. But
I don't want to cut you off in your sufficiency argument, Mr. Flanagan, but I was interested about your confrontation argument.
well, I think I've sufficiently covered the sufficiency, so I'll move on. Confrontation. Trying cases for 42 years, a jury trial is a street fight. We're now up here in an academic exercise. Street fighters object to everything and worry about how they're going to explain it later. The state cites a case, Holmes, and I think Judge McMullen was on that case. In that case, the defendant never objected to it. I objected to this officer testifying by Zoom.
Well, to be clear, the record does not provide a basis, a clear basis. Now, what you said was something to the effect of, you know, we don't want it, and I'll let it go. I'll let it stand at that. And then later on, I guess 2 or 3 pages into the transcript, I think you did say something to the effect of, I think it would be better for my client if I was able to cross-examine in person.
Yeah. There's a difference,
Yes.
but I submit, between articulating and preserving the record. I objected. It came in. It violated the confrontation clause in the state of Tennessee, which has one of the strongest.
Well, it's not absolute. I mean,
Well,
you know, you already cited Holmes. You know, we have allowed a relaxing of the confrontation clause for public policy purposes, when the state establishes that. And the Supreme Court allows for that. The United States Supreme Court allows for that, which is why we do. And I know the Tennessee Constitution provides for greater protection, but we've got cases allowing for that. Do you not agree?
I agree with that, but that Seals case, I mean, you know, I go back to hearing this thing. In Tennessee, face-to-face means face-to-face. And I think that's still the law in Tennessee. There may be some movement around that, but I think as I stand here today, that's the law. So I don't think it was waived. I think it violated his right to confrontation.
But, so tell us what the prejudice would be.
Well, and I thought about that because, you know, one of the things that we have difficulty in showing to a court is prejudice. It's not allowing the jury to see the person testifying face to face.
But isn't this witness's testimony cumulative?
And the state's going to argue that it was cumulative. His
Do
testimony
you
was
agree or
cumulative.
disagree with that?
Well, every witness the state puts on in every criminal case is cumulative, or they wouldn't put them on.
That's not true.
Well, I think
Different
that's
witnesses.
my
I
view.
mean,
of
it depends on the case.
But I think there is prejudice in allowing this particular, because he gave testimony about what he saw and what he observed. So I think, you know, I would argue that there's prejudice. But
Did counsel have access to the witness before trial for the purposes of interviewing?
counsel had access to this witness in a very hostile preliminary hearing.
So he'd actually been cross-examined previously?
He had been cross-examined.
And can you describe, to the extent that the record reflects this, what did the technology look like here? I think we're talking about two-way video conferencing. Who could see what? Was there a practice run conducted of any sort before this witness went on live? Can you tell me only what the record reflects on that? But can you shed any light on that at all?
Well, you know, as an officer of the court and an honest person, it was a typical Zoom hearing. So
the
that
jury,
is what it is. We could see him, we could hear him.
what could he, do you know, and does the record reflect what he could see as he testified?
I don't know the answer to that.
Okay.
I mean, I wasn't concerned about the technology part of it, Your Honor. I was just concerned about the fact that he wasn't sitting there. It's not in the record, but based on my cross-examination in the preliminary hearing, I wanted the jury to see him face to face. So I'll leave it at that.
So this area of the law is in the process of being, I guess, more developed post-COVID.
It is.
Do you want to speak to the, I guess, the procedure that should be employed or that you object to under the United States Supreme Court case? I think this was Craig, or I don't remember the name of the case, but the primary case that allowed for two-way video conferencing to be relaxed if the state meets its burden or if the government meets its burden of establishing a public policy need?
Judge, let me answer it by saying this. I am lucky that I can even make a phone call on my cell phone. So we'll start there. I don't like it. I don't want it. But from a legal standpoint, that's where we're headed someday. And I guess we've tried it here where we can do it by. But look, that's where we're headed. And I understand that, but I don't like it. I don't think it's fair to defendants. And I'll leave it at that. Thank you.
Thank you, counsel. Mr. Ball?
May it please the court, good morning. Once again, I'm Ben Ball on behalf of the state. Here, I'll start with the confrontation issue. The defendant has waived this issue. At no point during this trial did the defendant argue that this violated his confrontation right. It was a general objection to Zoom.
Well, now, he did, if I'm reading the record correctly, I think counsel said quote, "I think I can do a more effective cross-examination personally."
And with all due respect, that's not a confrontation objection. He has not once invoked the United States Confrontation Clause or the Tennessee Confrontation
Aren't
Clause.
you asking us to have a hyper-technical reading of issue preservation here?
I'm not asking for a hyper-technical reading. I think I'm just asking for a reasonable reading for the defendant to identify what constitutional right he claims is being violated. And it's our position that he did not do that here. And he has not established plain error. And I
So
think
is the fact that he also preserved it in his motion for new trial, I think in this case, further support for the fact that he objected and preserved the issue? Because the whole point is for the trial court to be able to rectify the problem, and then for us to be able to review whatever issue was objected to or occurred below. Is that not what happened here?
that is not what happened here. That problem needs to be clearly identified for the trial court in an objection, and it was not. And we're talking about two different confrontation clauses here, as counsel's noted. I mean, he's talking about how the Tennessee Confrontation Clause may be offer stronger protections than the federal Confrontation Clause, but neither was identified for the trial court. There was no confrontation objection here. And the defendant has not established plain error, as Holmes shows. There's no clear and unequivocal rule of law breached. There's no substantial right adversely affected here either. Mr. Marsh's testimony is largely cumulative, duplicative of Mr. Knight. These were the two, essentially, rescuers at the scene, and I can touch on their actions more a little in sufficiency. But these are folks who were there at the wreck and responded, and they saw largely the same things. And there's no allegation here as to how this technology affected the outcome, how the defendant was prejudiced here. What we're talking about, he's talked about preferences. We hadn't talked about what did the jury not see? What was he unable to get during cross-examination from this witness? Did the technology malfunction? None of that has been established.
Is the state going to take this opportunity to advocate for a particular approach to this issue?
I think this case doesn't offer a good opportunity to do that because it wasn't identified early on and then allow the trial court to address it. So I think this is not a good vehicle for that. So I would ask this court to find that this is waived and the defendant hasn't established plain error. Now, as far as the sufficiency of the evidence, and I'll try to be brief on this point, as your honors have covered a lot of the points that I intend to cover. First, the defendant here, there was ample proof the defendant was intoxicated. As your honors noted, he admitted to pulling over and shooting up shortly before the accident. There were needle caps, needles, syringes, and filters found in his truck. And he tested positive for fentanyl, and he behaved, the nicest way to say this is erratically. And what he was doing was he was stopped in the road in one lane. And as cars would come through the other one, he would pull in front of them in this sort of strange cat and mouse game, attempting, I guess, to disrupt traffic. Eventually, when one of these drivers tried to get around him, this, I guess, was unsatisfactory to the defendant, and he accelerated through the median and into the victim here. That is evidence of intoxication as well. And this is not asking a jury to speculate. These are rational inferences given this evidence. And there's no question that he caused the victim's death. And for those reasons, this court should find that the evidence is sufficient here. If there are no further questions, I would ask this court to affirm.
Thank you, Mr. Ball.
Thank you.
Counsel, you have your rebuttal time.
Face to face. That's the difference between a witness coming into court and testifying against somebody. And that's what the cases talk about on the Tennessee Confrontation Clause. It's face to face. Thank you.
All right, thank you to both parties, and we'll take the matter under advisement. Madam Clerk, you may call the next case.